Yes, sir. Your name? Robert Bigham. Your Honor, today's time and date set for probable cause conference. I was appointed 2 days ago. I did get the discovery yesterday, and a lot of videos came in yesterday. I have not had the opportunity to review those with him. I'm asking for a 2-week adjournment. Any objection?
The adjournment that I would like to address bond.
Probable cause conference will be adjourned to March 28, 2024, 9 a.m. as to bond.
Requesting either revocation of bond or to renew our request for $100,000 cash surety in this case.
At the very start, what seemed like a routine court hearing quickly turns into a fight over the defendant's bond. The defense attorney says, "Wait a minute. I just received a huge amount of evidence and video footage yesterday, and I need more time to review it." That request is fairly normal. However, the prosecutor immediately raises the stakes by asking the judge to either revoke the defendant's bond or greatly increase the cash amount required for release. This shows that prosecutors already believe the defendant may be a serious risk. Even before all the evidence has been fully reviewed, Judge Simpson keeps the case moving forward, but still allows the prosecution to address the bond issue. This shows a balance between efficiency and caution. The moment bond becomes part of the discussion, everyone in the courtroom understands that the defendant's freedom could be at risk. At this stage, factors such as the defendant's criminal history, past behavior, compliance with court orders, and public safety concerns become more important than sympathy. Cases like this often stop focusing on a single charge and start examining the defendant's overall history and behavior. That is exactly the direction this case appears to be taking.
The revocation request is, we have received a community corrections violation. The defendant has never appeared at community corrections and has failed to ask for anything. So on that note, I'm requesting revocation of the bond and an immediate remand. However, in addition, at the time of charging this case, before I go on, do you have the community corrections?
I do not. I received it yesterday, Your Honor.
I sent it to defense counsel, and I can forward it to
Anne. Provide you my copy. Go ahead, Ms. Hughes.
At the time of charging this case, my office requested a $100,000 cash surety bond. The defendant does have an extensive criminal history in the sense that he has been convicted starting as far back as 2000. He was convicted of misdemeanor drug possession. In 2003, he was convicted of domestic violence. 2004, he was convicted of fleeing third. That's noteworthy here because this is a fleeing third case as well. In 2008, he was charged with but not convicted of domestic violence third offense. In 2011, he was found guilty of resisting and obstructing of a life offense of carjacking and another carjacking and an attempted. That is his most recent, those are his most recent felony convictions from 2011. From that case, he was sentenced to 2 years to 5 years in the Department of Corrections. This is a fleeing and firearm case now, and his guidelines on this case are 14 to 28 months without a habitual. So this is like the best case, but at the very minimum, it doubles the 28 snap that I believe is 59.
Prosecution is putting more and more pressure on the defendant, and this is the type of argument judges take very seriously. Notice what they are doing. They aren't focusing only on the current charges. Instead, they are presenting a long history that goes back many years, including drug offenses, domestic violence allegations, felony convictions, carjacking-related crimes, and prison time. Prosecutors often use this approach because it makes the defendant's actions look like part of a continuing pattern rather than a series of separate mistakes. Then they shift to the allegations involving dangerous driving, which raises the stakes even further. Once the state starts talking about high-speed driving, going into oncoming traffic, fleeing from police, and putting other people at risk, the focus changes. The defendant is no longer seen as someone simply waiting for trial, but as someone who may pose a danger to the public. That is important because bond decisions are largely based on public safety and whether the defendant is likely to follow court orders. The prosecution is essentially arguing that this is not someone who made a single poor decision, but someone whose behavior has become increasingly reckless over time. They also bring up potential sentencing guidelines. That is a strategic move because it encourages the court to think about the possibility of a lengthy prison sentence. The prosecution's argument is that the greater the potential punishment, the greater the risk that the defendant might try to avoid prosecution or fail to appear in court.
That's correct. In this case, the defendant was driving erratically, so erratically to the point that he, at one point, was driving on the opposite side of the road into oncoming traffic in an attempt to evade the police. His speeds were, as far as I can see from the report, as high as 50 miles per hour in a 35 mile per hour zone. He put not only the police in danger, but also the community. Then, in addition to that, as you can see from the other charges, after the police, so at some point the police did have to terminate the word. Thank you. Chase pursuit. Thank you. Team effort. Because of how dangerous it was. Instead, they continued to follow him at a safe distance. Once he stopped the car, he got out of the car and continued to flee from the police on foot. While the police actually yelled at him, he was going to be shot. They were going to shoot him if he didn't stop running from the police. They were able to take him into custody, certainly without him continuing to assault and obstruct them first. Then, while they were inventorying the car that he fled in, they recovered a magazine from a handgun. This is a convicted felon, multiple times over. They knew, based on their experience, that typically where there's a magazine, there is a handgun. And they discovered a handgun on the route and he fled from them. In addition to that, however, they also found, they also suspected, that he was under the influence. So we are waiting for his blood results still. Refused any testing. The blood testing is still in the lab. And then, as you can see from your charges as well.
The prosecution is now increasing the pressure even more. At this point, the hearing is no longer focused only on fleeing from police or violating community corrections rules. New issues are being introduced, including possible intoxication, a suspected firearm, and white powder evidence. This is a common strategy prosecutors use during bond hearings. They present information that is still being investigated while emphasizing the potential risks. Pay attention to the language being used: suspected, awaiting blood test results, and still being tested. While the evidence is not yet complete, the prosecution is arguing that the overall situation suggests the defendant may pose a significant risk. The firearm allegation adds another serious element to the case. According to the prosecution, officers found a magazine, believed a gun might be nearby, and later recovered a handgun along the route. If the defendant is a convicted felon, that allegation could have major legal consequences and increases concerns about public safety. As soon as firearms become part of the discussion, judges often pay even closer attention because they can affect decisions about bond and pretrial release. The prosecution is using these allegations to support its argument that the defendant may be dangerous and unlikely to follow the law if released. This is also the stage where bond hearings can begin to resemble an early preview of trial arguments. The prosecution is introducing key themes it may continue to emphasize later, including danger to the public, reckless behavior, disregard for authority, and possible involvement with controlled substances. Step by step, they are building a broader narrative about the defendant before the trial has even started.
He was in possession of a baggie that had some type of white powder in it. This was something he left behind in the deputy's tried to. Your Honor, I'm requesting either just straight revocation, bond denial, or his bond violation of failing to ever go to community corrections, or I'm requesting the $100,000, which was already the request in this case. Thank you.
Mr. Jervis.
Your Honor, he was arraigned on February 12th. He did post his cash or surety on the 18th of February. He had a PCC on 2/22. Everybody was in court the last hearing. That was not addressed regarding his testing. He obviously got out. He didn't go to community corrections. He was unaware at that time. No one reminded him on the 22nd. I got the bond violation yesterday at about 4:10. I called him and told him to go to community corrections immediately. Got back on the phone with him, told him they closed at 4:30 to show up at 8 in the morning. He was there 8 in the morning to try and do an intake. They would not take a test, or they would not do an intake this morning. He was told due to the bond violation. His mother is here with him today. He's obviously showing up to court. He's not driving. He was in his mother's car. As far as, minimally, I don't know the full facts of the case. I did start reviewing some of the video. I do understand that there may be another occupant to that vehicle. I'm not too sure on who the actual driver was of that vehicle, be with 2 occupants. So regarding, I'm asking that the bond remain. I'm asking that he report to community corrections today, allow him to do the intake, and continue on a testing.
Why didn't he go test?
That question from Judge Simpson could be one of the most important moments of the entire hearing. When a judge starts personally asking detailed questions about missed requirements or compliance issues, it usually means the court is taking those concerns very seriously. The defense is trying to explain the situation as a misunderstanding, a communication problem, or failure in follow-up by community corrections. However, the prosecution has already argued that the defendant was informed about the testing requirement after arraignment. Because of that, the court's focus becomes very straightforward. If the defendant was told to comply with the conditions, why did the required compliance not happen? The defense's explanation faces challenges because courts generally expect defendants to keep track of their own bond conditions. Arguing that nobody reminded the defendant may not be very persuasive, especially when the conditions were part of a court order. The timing also creates difficulties for the defense. If the defendant only contacted community corrections after learning about the violation, it can appear reactive rather than proactive. From the court's perspective, taking action only after a problem is identified may not demonstrate a strong commitment to compliance. This issue becomes even more significant because it fits into the broader concerns already raised by the prosecution. When a defendant is facing allegations involving fleeing from police or resisting officers, any additional failure to follow court-ordered conditions can strengthen the prosecution's argument that the defendant has a history of non-compliance and poor decision-making. As a result, what may seem like a simple missed requirement can become a major...
I don't know. And the other thing is no one reminded him the last time that was in hearing.
Okay, but he was told at arraignment to go test.
I understand. He was in custody at the arraignment and didn't post until 40 or 6 days later. So when he got out 6 days later, he didn't go and test. That is correct. And then he showed up 4 days later to his last hearing that got adjourned until today.
In regard to we don't know if he's the driver, he's being pursued by the police straight out of the driver's seat. They watch him get out to seat and they pursue him, they arrest him. So there's no break in that pursuit. I emailed community corrections yesterday asking for a community corrections update on him. Basically, I was looking for more fuel for this fire of this argument. They forwarded me that bond violation. I did not have a copy of it. It looks like the court didn't have a copy of it last time we were here.
We were here on what day?
The 22nd.
Something tells me that it was dated the 21st. I don't know what time it came. It actually is in my file, but I'm not sure when it came down because it doesn't appear that it was here the last time that we were here. When was he released from prison? 13.
This exchange may have been short, but it reveals what Judge Simpson is likely considering. The judge appears to be weighing the defendant's past criminal history against any signs that they have changed their behavior over time. In bond hearings, judges often look for evidence of rehabilitation, such as years without new offenses, stable employment, compliance with supervision requirements, and a lack of recent legal problems. However, in this case, the court is hearing allegations that the defendant was involved in another dangerous incident while already having a significant criminal record. A key moment comes when the judge asks whether the defendant would pass a drug test if sent immediately to community corrections. The response is uncertain, which creates a serious problem for the defense. Instead of reassuring the court, the answer raises additional concerns about compliance and possible recent drug use. Bond decisions are heavily influenced by credibility. When a judge asks a direct question and receives an uncertain answer, it can have a greater impact than lengthy legal arguments. The court may view that uncertainty as evidence that the defendant is not fully complying with expectations or conditions of release. As a result, the judge's focus may shift away from giving the defendant the benefit of the doubt and toward imposing stricter conditions. In many hearings, decisions are shaped by moments like this. Small exchanges that provide insight into a defendant's reliability, judgment, and willingness to follow court orders. From the prosecution's perspective, this exchange supports its broader argument that the defendant presents ongoing concerns regarding compliance and public safety. For the defense, it is a difficult moment because it undermines efforts to portray the defendant as someone who can be trusted to follow the court's requirements.
2013.
2015, his parole is now expired.
Pardon?
His parole's expired.
Send him over there right now. Is he going to test clean?
The answer to that is questionable, but it will probably come back.
Questionable.
Well, I do have the belief that he at least used marijuana prior to the last few days.
And the defendant's bond is increased to $50,000 cash surety. Defendant's remaining.
Thank you, Ron.
Versus Ryan Johnson.
Morning, Your Honor. Mark Creech on behalf of Mr. Ryan Johnson is approaching. If I may proceed, Your Honor.
Your name, sir?
Ryan Johnson.
Thank you. Go ahead. What are we doing?
As far as the PCC, my client is requesting a preliminary exam.
Discovery complete.
Yes, Your Honor.
People have their witnesses available to 26.
Your Honor, I'm unavailable to.
Your Honor, this is the co-defendant for Julius Clay. Are we wanting to keep them separate, Ms. Kreischer, or are you inclined to keep them on the same day?
As one heated bond hearing comes to an end, the court quickly moves on to another serious criminal case involving Ryan Johnson. At first, the discussion seems routine, focusing on scheduling issues, preliminary examinations, co-defendants, and witness availability. These are common topics in criminal proceedings. However, the hearing becomes much more serious when the prosecution outlines the allegations. According to prosecutors, two individuals, a parent and grandparent, were allegedly held at gunpoint. They further claim that the incident escalated into a standoff that required the involvement of SWAT teams and multiple law enforcement agencies. By emphasizing these details, the prosecution is presenting the case as one involving significant danger and risk to the community. Their goal is to convince the court that the allegations are severe enough to justify strict bond conditions or continued detention. The defense takes a very different approach. Instead of focusing on the allegations, They highlight factors that may suggest the defendant is stable and connected to the community. They point to family support, local ties, employment at Applebee's, and people present in the courtroom who are willing to support the defendant. This creates a clear contrast between the two sides. The prosecution emphasizes the seriousness of the alleged conduct and the potential threat to public safety, while the defense focuses on the defendant's personal circumstances and potential for rehabilitation that are in many bond hearings. The judge must weigh these competing narratives. One side argues that the defendant poses a danger or flight risk, while the other argues that the defendant has enough community support and stability to be trusted while awaiting trial. The judge's decision often depends on which argument is more convincing when viewed alongside the evidence, criminal history, and overall circumstances of the case. Ultimately, bond hearings are not just about the charges themselves. They are often about whether the court believes the defendant can safely and responsibly remain in the community while the case moves forward.
Back on the record, preliminary examination in this matter will be set for April 2nd, 2024, 9 a.m. That's in person before me.
Your Honor, my client insists that I address bond.
Go ahead, briefly.
Your Honor, my client has family here in the community. He's lived in the community for a long time. He indicates to me that his family would ensure that he would return to court. He also, prior to his incarceration, had a full-time job at Applebee's as a cook, which he would like to.
The allegations are that he held two people at gunpoint, a parent and a grandparent at gunpoint.
Those are the allegations.
And then took an infant to a hotel off the premises, which required SWAT and multiple teams of law enforcement to respond.
Go ahead with your argument, Ms. Carter.
He assured me that he would return to court. He would ask this court to, his bond, I believe, is currently at $5 million. He's asking for a
And
reduction.
I don't think that's high enough, given what I see here. But go ahead.
And he would be requesting a GPS tether.
Denied.
Thank you, Your Honor.
Here's a simpler version of your text. This is where the defense's optimism clashes directly with the judge's concerns. The defense is trying to reduce a very high bond by pointing to things like the defendant's job, family support, and promises to return to court. But Judge Simpson's reaction makes the situation clear. When the judge suggests that the current bond might actually not be high enough, it shows how seriously the court is treating the allegations. The prosecution has described the case as involving a dangerous armed incident, vulnerable victims, a hotel situation, and a SWAT response. Once details like that are part of the record, judges tend to be very cautious about releasing someone. Across both cases discussed today, the main focus has been the same: public safety and compliance. Whether it involved fleeing police, failing to meet supervision rules, or serious allegations involving weapons and intimidation, the judge kept coming back to risk rather than convenience. The key point is that bond hearings are not about deciding guilt or innocence. They are about whether the defendant is a danger, whether they can be trusted, and whether they will follow court rules while the case is still ongoing.